morning and welcome back from the break. Up next, we have Julian will present on Indigenous law and the education reset pathway forward, along with Deputy Grand Chief Narcisse. But before we get to that, we had one question that was submitted in the chat box prior to us closing off this session, our last session. The question is, can we apply Choose Life funding in our department in education, but our First Nation health applied? Will it interfere? I'm going to ask Deputy to address that question.
Yeah. Hello, welcome back, everyone, and thank you for that question. I know that there's even some of our educational institutions and some of our First Nation communities are administering the Choose Life program. I know it's up to the First Nation and the community as well, and we're always insisting that we want to tear down silos even within the communities as well, and we encourage that communication as well in terms of perhaps it would also complement your community's structural plans or community plans in terms of looking at resources to help your children, youth, and families. So I encourage those discussions to happen even at the community level, to reach out to your First Nation and all different players, saying that you want to give notice, or how could we create a Choose Life program within the community that encompasses all these different areas and partnerships and in moving ahead. But in terms of individual structures within the community wanting to apply to Choose Life, we could get some more clarification on that as well. So if we could get your contact information, and if you just send it to our administrators over here, and we could follow up with you. And that's a great question as well, because I know Choose Life has taken on many forms since its inception. Working within schools, working with mental health pieces within the health system, complementing a lot of the work that's happening with the prevention dollars that are going straight to the First Nations with respecting children, youth, and families. So a lot of work stems from all these resources being applied to the First Nations. I know sometimes it's we have to disentangle them, but we could help with the navigation piece as well. So we'll be in touch as well to help you along with your applications process too, if need be. But So I guess am I introducing the next portion? So in this, thank you, Julian, for that presentation this morning. Just getting us why we're doing the things that we're doing it this way, in terms of setting the pathway forward. Making the best use of our leadership's time in terms of these negotiation processes, and the respect that should be given to our leadership and our education directors and education councils, in terms of doing the work that needs to happen in the pathway forward. And it is the pathway forward that we want to also discuss. And also with respect to all these different areas that we need to really take into consideration by really scribing our own Indigenous laws on education. What the both levels of government need to do in terms of enacting legislation to really to respect Indigenous laws and moving ahead, and how we are supposed to be positioning and resourcing our First Nation communities and our partners in doing this very important work. And we heard it from our partners yesterday. There's various interpretations of how they see treaty, and how it's a birthright, and how our laws have been paramount since time immemorial, and how those laws and should be respected. And it's so this presentation is going to be done by Faulkner's LLP, is looking at the Indigenous laws and and how it affects the education reset table that we are embarking on. So Without further ado, I'll turn it over back to Julian Faulkner. Thank you.
Thank you, Deputy. And I just want to make sure, first of all, I was having problems with my audio. Jeremy Greenberg, my associate, is going to be working with me on this portion of the presentation. Jeremy, can you hear me okay? And can you turn off your mute, please?
I can, yes. Hello, everyone. Nice to be here.
Perfect. So the plan is, first of all, just to tie off where we are at in terms of what we talked about before the break. And I just want to emphasize, when we talked about leveraging for success and taking, wins in other sectors and applying them, here's very good examples. In the case of Choose Life, thanks to Wapakika's application, we identified an application procedure that was community friendly. In other words, Wapakika had created the format of the application. And so we took the Wapakika application and we applied it to a template for all communities to apply for funding to support youth at risk. And so that's how we came up with the user-friendly application process. And then we, in the Choose Life context, said, we need an expedited track so the red tape doesn't apply. And so all of that happened, and we say, consistent with Deputy Grand Chief Narcisse's vision, we should be able to take some of the same principles in terms of education and say, okay, let's create user-friendly processes to build schools. Let's create an application process that doesn't victimize communities and make them start all over again when they don't meet certain protocol realities, such as, my good friend Chief Boisneau in Matagami is facing in terms of his efforts to build a school in his community. We need to identify what doesn't work, processes that are not user-friendly, and trade them in for application processes that do work. And then secondly, and as importantly, it's got to be expedited. It can't be something that sits there for months, years. And so we measure successes by decades, right? Because respectfully, that is what's going on right now. Successes are measured in the education area by decades. And so obviously hugely important work took place in order to identify the policy framework document in the late 1990s. I think 1999 was when it was signed by leadership, and obviously an incredibly important moment. And I want to acknowledge that. And it took from 1999 to 2018 to sign an agreement in principle. And how long till, like, we can't measure success in decades. That should stop. And you should be more impatient, respectfully. And how do you push that? Well, this is where I go back to the negotiation piece, right? It's about decision makers at the table, so the parties. It's about, so important, a strategy. It's about leverage, and it's about timing. But if you bring all these things together, successes stop being measured in decades. And so the major impediment to a lot of these decisions is the issues over funding, the quantum of funding, and it not being enough and it not being sustainable. And that's where the RQ work comes in, because the remoteness funding is about taking into account the actual realities of the North and your challenges, whether those are capital challenges around building, recruitment challenges around teachers. The RQ work actually factors these things in. In other words, it actually values what a dollar looks like in the North and what the human resources challenges are in the North. And it requires additional funding to overcome those challenges. So these are the wins Deputy's talking about, and that was the last presentation. I'm now going to move on, but I wanted to make sure we recap this properly. I'm going to move on to the Indigenous law piece. The connection between the path forward and the discussion around Indigenous law, I'm sure, is obvious to all. It was so important to hear from the leadership yesterday when you spoke about what your expectations were. And I'm going to quote from one of the panels again, right? When it was Matthew Angies who said, why are we discussing education as a treaty right? Education is our birthright. And I just want to pause and reflect about what the history of Indigenous law is supposed to be about. And it is very much supposed to be about your systems, not, not the settlers' systems, what I'll have to guess call including my system. It's supposed to be about your system, and it's not supposed to be about what Mike McKay warned about. Outsiders continue to tell us what is right and good for us, what we can and can't do. It's not supposed to be about that. A judge made an observation in a case that I argued last year, because we were arguing in that case for Treaty 3 for Iskatewazagagan number 39 in respect of the taking of their water by Winnipeg. Winnipeg is the sole source of drinking water. The sole source of drinking water for Winnipeg is the lake, Shoal Lake, Iskatewazagagan number 39 territory. And I just want this quote from the judge to be put and screen shared with you, because it speaks to trying to break through to the judges about what we're actually talking about when we talk about Indigenous law. So Jeremy, I'm hoping you can screen share the quote. It comes from Justice Perel. And I want to emphasize that it shouldn't matter where or how you are analyzing the question of your history. It should be very much about who you are and the birthright that I thought it was so eloquent that Matthew referred to. Obviously, somehow we're having, there we are. Thank you. So Justin, another member of my team, will be ready to take over the screen sharing if this isn't working. So Jeremy, text Justin and let him know if you think this isn't working. We can't delay like this each time. So Justice Perel observed the law that, and I'm reading from the judgment, that we were successful against the province of Ontario in getting an order that there's a fiduciary duty that attaches to the taking of the water. In the judgment, the judge started off this area by saying, the law that governs the relationship between Canada and Aboriginal peoples of Canada is what is now known as Aboriginal law. Indigenous law is not the same as Aboriginal law. Both before and after the arrival of European settlers, the Aboriginal peoples in North America had well-developed civilizations that had legal systems and legal customs. Those discrete legal systems are the source of Indigenous law, the law that governs the first cultures as discrete civilizations or civil societies. And so you'll see, and this is the cool part, a judge got it, right? He got the fact that what we are talking about is not something that needs his approval, right? Or his seal of approval, that it exists already. And it has existed from well-developed civilizations that had legal systems and legal customs long before the arrival of settlers. So let me stop the screen sharing for a moment, because I get all distracted by it, and raise something with you to talk about. So I'm alive to the fact that it's a bit rich for a non-Indigenous lawyer then to be talking to you about what is your culture. So I get that, and for that I humbly apologize, but I'm trying to help. But I do get it that, I have to be respectful in recognizing that it isn't my culture. I don't know, make the joke that I don't know if there's Jamaican Polish law out there that gets it right, but I understand that it is for you to decide what is and is not Indigenous law, that's your birthright and that is your world. But I'm trying to bridge the worlds, right? I'm trying to talk about what we're able to accomplish in a courtroom, what we're able to then accomplish in negotiations, and ultimately how we can drive reform. So that's why I'm talking about this. And so when Deputy Grand Chief Narcisse talks about an education reset, we observe that the truth of the matter is, if the education reset is going to have context, it needs to have the context of Indigenous law. And it does have a meaning. You know, there's a lot of words that are kicked around about what Indigenous law is. I want to make this observation. No PowerPoint in front of me, nothing, just talking. So the first thing Indigenous law is not, I'm going to say this respectfully, is it's not Indian Act bylaws, all right? I'm not saying it can't be. I'm just saying that respectfully should not be how you define your laws, whether a bylaw was passed under the Indian Act. But sadly, you hear a discourse pretty routinely where the expressions of frustration around the failure to enforce Indian Act bylaws then turns into a discussion of a failure to enforce our laws. We hear those words. Because I also act on the policing files, I hear them regularly. But reflect on that for a moment. Is the statement that your only laws are those passed under the Indian Act, like these bylaws, whether it's around intoxicants or trespass? I'm guessing that you see Indigenous law as going well beyond the Indian Act. And I know the speakers yesterday actually spoke directly to that point. And I'm speaking to that point, that Indigenous law is not simply Indian Act bylaws, but that's how some would have you believe. And specifically, that's what, as an example, I can tell you lawyers in the Ontario government, many of them believe that the only way you can pass a legitimate law is by invoking the Indian Act bylaw process. And that's a disgusting disrespect for Indigenous law, the very Indigenous law that Justice Perel refers to. But I would go a step further. There are a number of different ways, in my opinion, as a lawyer, I believe Indigenous law can be passed today. And what do I think they are? Well, examples are, you know, a proper, formal, appropriate governance BCRs could absolutely reflect Indigenous law. I like to say to chiefs who ask me for advice, you know, it can't be a BCR you passed on a napkin, right? It needs the appropriate credibility of your community's leadership, whatever that leadership is. And it needs to be reflected enough on paper so you can get the message across that this is a law. So I use that as an example because that's, you know, if you talk to half the or more of the people out there, they will tell you a BCR can't be law. Well, that's nonsense. Of course it could be law. It just depends on what the BCR says and how it's drafted to properly reflect the will of the community. That's an example of an Indigenous law that could be, and that we're in this PowerPoint presentation, I propose to show you it can be done. But it's not any BCR that you could credibly say is law. It's not for me to say. But like I said, if you passed a BCR on a napkin that wasn't the will of chief and council and wasn't the will of the community, you just said BCR and you wrote something on it, well, that would be a problem. Just as I'm sure it would have been a problem for the leadership 8,000 years ago, or at any other time. It's got to be credible, right? But you decide what's credible, not me. I get that. The issue of Indigenous law has been the subject of extremely important research, specifically at the University of Victoria. Professor Burrows at the University of Victoria, Professor John Burrows, an extremely respected Indigenous scholar, has created the Indigenous Law Research Unit. And he discusses the principles of Indigenous law. Now, I'm going to screen share what he has created as his visual, right, of what Indigenous law is. And when I screen share this, the first thing I'm going to observe is, wow, that's complicated. My associate, Jeremy, is going to, in sort of 3 or 4 minutes, without talking too fast, but go slow, take you through this diagram, this visual production of what Indigenous law is. Professor Burrow calls this Indigenous Law 101. Go ahead, Jeremy.
Sure, thank you. Yes, so I've actually had the honor of studying with Professor Burrows as well when I was in law school. So I've actually visited his community, the Cape Coker Reserve. So really what we wanted to sort of draw attention to in this 101 was the key aspects about the sources of the law and the methodology, and a bit about the sort of resources, really all stemming from this idea of where Indigenous law comes from and what we're used to. And again, I totally speak as a settler trained lawyer, non-Indigenous person. My head is often stuck in statutes, laws, court decisions. But one of the things I learned from Professor Burrows, and I'm happy to share in this illustration, is this idea that it's so much broader than that. So you have these sources of Indigenous law. This is things that I've learned, and I accept that I don't understand it nearly as well as many people in this room. But learning from the sacred, from the natural world, the customary law that's developed really dating to time immemorial for First Nations communities, deliberation, so community consultations, discussions, ongoing social interactions. So Professor Burrows would take us on a walk through the forest and talk, share stories of the spirit world, of animals, as you see in the illustration, and then also positivist law, which is just a fancy way of saying that there are authorities, right? So in a given community, and you see this here, you see elders, you see stories so there are authorities that might be recognized differently in each Indigenous community, each First Nation, individuals who are recognized as knowledge keepers. So all of these things sort of working together, which is really different from just saying a judge said this or the criminal code says that. And it all ties into this methodology, which frankly we could probably do better with ourselves as a law firm. But this looking at the specific research question, workshopping, story analysis, focus groups, synthesis, evaluation, implementation. So I guess maybe the word I would use is holistic. I'm not sure Professor Burrows would use that, but really just rethinking and reconceptualizing the way we approach the law from this Indigenous broader perspective, working with many different parts of the community. And then as we'll be talking about, and Jillian will be talking about in a moment, that we've had some experience with this now working in NAN communities on these Indigenous legal approaches. So sitting down and saying, how do we get away from that Indian Act paradigm potentially, work with elders, work with community members, community consensus decision making. We have tons of experience of that. It's obviously a lot different from some of the clients we deal with in the non-Indigenous world. So that's really all I wanted to share from this illustration. And just, I think the next slide really says most of what I just said. So this idea that it's a decentralized, you have horizontal thinking instead of top down. That precedent doesn't just mean judges, right? It means oral traditions, it means discussions in the community, a balancing of individual rights with the needs of the community. And then I'll try my best to pronounce it, but this concept, which I've encountered, Professor Burrows, Nakanige, so this idea in Ojibwe Anishinaabe tradition of deliberation. So which I kind of think, and I hope that that's partly what we're doing today in our own way, is everybody's meeting here to talk and to deliberate and to think about ways to approach the law in the education sector. And maybe I'll just turn it over to Julian on
That's
that
great.
note.
Thank you, Jeremy, and that was very helpful. Jeremy, if you can switch to page 29, we're looking at taking our lunch break, if that's okay, at 12:30. Jocelyn, Deputy Grand Chief, sent me a text. I wanted him to know I saw and heard the text. So we're gonna move things quickly. I want to again emphasize that our problem is, I respectfully suggest the problem that we're confronted with in attempting to implement Deputy's vision is Ontario is mired in a very conservative, non-innovative view of what is law, right? So Ontario's public education system was built according to an education philosophy that's common, from the Industrial Revolution, right? Teach children the basic knowledge and skills they'll need as laborers. And as what that's meant, as with many colonial institutions, the needs and worldviews of First Nations are not considered, right? Now, Ontario is making some small steps towards Indigenous education, but it is trapped in a colonial mindset. And I have regard to, Charles Brown's, story about the youth who is accomplished in being with the lands, right? And his accomplishments with the lands and his community, but then seen within the traditional view of education as a failure. And that obviously represents the failure is actually on the part of the colonial society. The failure isn't on the part of the youth. We need to fix this. We need to close this. We need to bridge the two solitudes. An example is the alternative secondary school program. Now, this alternative secondary school program offers standard Ontario secondary school curricula, right? Cultural programming, they call it cultural credits, and promotes Indigenous student success and provides an alternate learning environment for Indigenous learners wishing to obtain the diploma. While it allows for Indigenous educational process, in the end, it relies on colonial school models, right, in treating what they call alternative instead of simply Indigenous-led exercise. So what we keep seeing is a marginalization of your history and who you are in favor of a colonial cited experience. Next page, please. Ontario's education system is outdated and it struggles to meet the needs for all learners, especially First Nations. Now, NAN has an opportunity to build a world-class education system, and that process has started. To be at the forefront, right, it means being innovative. Lessons can be drawn from Indigenous education initiatives in other communities, British Columbia, Nova Scotia. I mean, we heard just the brilliant and interesting work done by the Mi'kmaq and others. Anishinaabe nations obviously made important inroads. So how do we combine NAN's success in other areas, and how do we inject it into innovative legal education and innovative education generally? Now, I'm going to use one or two examples of different ways of thinking, and it's designed to give you an opportunity to understand. Again, deputies said, I want to take successes in other sectors and apply them and see how they could work in the field of education. If you go to page 7, please, Jeremy. So in an effort to address issues around COVID and the closing of communities, we created Indigenous law through BCRs. And those BCRs and the closure orders that flowed from them initially were resisted greatly. And under the leadership of Grand Chief Fiddler, the Attorney General changed his position and agreed to enforce NAN's BCRs. And so Indigenous law was respected. We have created, and it's still controversial, we've created a proposal around border control. That is controversial. We've also created a process for ensuring Indigenous representation on juries in the inquest system through a volunteer jury system. It's called Operation Invite, and at the 7 Youth Inquest, a woman from Sachigo Lake was on that jury by virtue of the volunteer system. All of these are examples of NAN using innovative approaches to create Indigenous law and then have it enforced. And to use one example, all right, and you can go to page 9, please. To use one example, we created a band council resolution model that relied on and this is in the context of COVID closure orders, we created a BCR that relied on the inherent Indigenous authority to make laws directed at health and safety. And we cited that in the BCR. We cited the fact of UNDRIP and Canada being a signatory, including autonomy and self-government in matters relating to internal and local affairs. So we insisted upon relying on UNDRIP. And we cited the inherent jurisdiction integral to the distinctive culture that the Supreme Court of Canada relied upon. All of that was used to insist that First Nations, and you can go to page 11, please, First Nations will have a right and an authority to decide who enters their communities, right? So that they would have the authority to allocate appropriate financial and human resources to support or augment the police service to enforce these laws. And then what I can tell you is, of course, absolutely, of course, resistance from the Attorney General occurred. Go to page 14, please. The Attorney General, and this is in the context of using BCRs to close communities, the Attorney General stated that they would not accept BCRs and that the only way it would have to be under an Indian Act bylaw. But then Grand Chief Fiddler pushed back, and the Attorney General recognized the legitimacy of the COVID-19 border closures through BCRs. And next page, please. He did that in correspondence of July 2020, where he actually acknowledges where charges are laid, right, by NAPS, they will be dealt with and prosecuted. That was Attorney General Downey's agreement. Offenses committed and charges laid under the Trespass to Property Act would be, again, prosecuted. And for remote First Nations communities, a request to the trial coordinator to add the matter to the list of fly-in courts would be respected. All of this is to say that in defining the path forward for how Indigenous law can be reflected in education, you can switch now to page 22, please. In defining the path forward, we need to talk about how to use UNDRIP, right? We need to talk about innovative approaches to education that are about using Indigenous law and using your ways. You don't need their agreement. You don't need their permission. But you do want to work with them as partners. And again, right, parties to the table. That's one of the pieces that it makes for a successful negotiation. Next slide. Indigenous law and education, we say, begins early, and it's in the home. It means learnings from elders and teachings from elders, learning sustainable practices and learnings from the community. There is far less of a distinction between who is a legal expert and who is a legal authority in Indigenous law than there is in colonial law. So lawyers are not the last word, all right? It's clearly not just about lawyers. And I respect and understand that. And we humbly make this presentation, not because we think we have some expertise on honestly what is or is not Indigenous law, but simply at the deputy's request, because we're trying to promote thinking on a path forward. Next slide, please. Yesterday, you heard from several education innovators about their communities. You know, Blair Gould was fantastic in terms of the Mi'kmaq presentation, and Tracy O'Donnell for Anishinaabe Nation. I mean, these are hugely important pieces to the exercise, and I want to acknowledge that it's very much about developing Indigenous law. The Nunavut case is a very good example. Next slide, please. In terms of what they've done, embarking on a wide-ranging education reform project. They overhauled the Education Act to encourage more Indigenous-centric education. So now, in the Nunavut case, the Education Act empowers each district education authority to hire elders to give lessons on land-based activities. Whether we're talking about caribou hunting, fishing, sealskin sewing, language lessons, other cultural practices, and each elder is formally certified under the Education Act. So you see this combination of traditional sources of knowledge with government sanctioned work. And I only raise these issues to make the point that being innovative, and next slide, please. You heard from Jordan Lester yesterday about the situation in BC. And I can't emphasize enough that I acknowledge that all of this is a piece of the puzzle. Suffice to say, in the end, 28, please. As Deputy Grand Chief observed, education is very much about stories. So much of Indigenous law is about drawing lessons from those stories. Deputy Grand Chief Narcisse passed along the Charles Brown story about that young man from who had attended a high school, and how the school had told his parents that he was failing some classes, that he did not excel academically. And but they did not see or understand that he was actually a good provider for his family. He had wisdom and skills in living on the land, hunting, trapping, and camping. And I had referred to this before, but what a perfect example of the huge divide between the two solitudes, right? The colonial mentality and Indigenous communities. I'm quoting the Deputy Grand Chief when he points out all learners have unique knowledge and skills, but if a fish is assessed based on its ability to climb a tree, it will be seen as a failure. And so ultimately, what we need to talk about in terms of future at page 30 is that we need to talk about innovations that see the outdated, struggling Ontario system rejected in favor of a Indigenous sited process. We can do this, we can accomplish this through the strength of the current processes in place, and through identifying a path forward that is fearless in terms of innovation. I thank you for your patience in listening, and I hope this was helpful in trying to show, one, the work done, and two, the potential for future development in the context of the education reset. So thank you, and I'll turn it over to Deputy.
Oh, okay. Yeah, no, thank you, Julian, for that. And yeah, just more or less sets the stage where we need to go, and we'll need to really look at various efforts for observing Indigenous laws and how it relates to the very important work that we're doing. So thank you for that presentation, and please forward any questions to us in the chat, or contact us later. We could also provide an in-depth presentation to you and your education council or your First Nation with the work that's going to be happening. So thank you, Julian, and your team. And I'll send it back to Jocelyn.
Thank you, Deputy. Thank you, Julian, for the presentation. We'll wrap up that session. The play to win code word for this session is journey. Please write it down and enter during the break. We are going to break for lunch, and we will reconvene back here on elements of local education code lawmaking at 1 p.m. Eastern Time. We'll see you in a bit. Have a good lunch.